and Cafe Private Limited, wherein so is one of the director and shareholder. The said company obtained premises administratively about 3,300 square feet along with right to use adjoining open area of 4410 square feet and upper mezzanine floor of 2,500 square meter situated at third floor of Trade House, Jamala Mills compound on lease and license basis from the owner of the land and the developer namely Royal Traders and Jamala Mills Limited. On the night of between 5 and 6 August 2021, there was an unfortunate incident of fire in the adjoining restaurant nearly 10 hours.
He was telephonically informed about the said incident by his manager after midnight at 5/8/2021. Sometime at about 1 a.m. of 6/8/2021, while he was traveling from Moot to Dubai, Moot was informed that the staff of his company has not only ensured that all the customers of the restaurant of the company of Moot are safely rescued from the fire. He was separate the restaurant of the company of Moot also, but they had saved the lives of many customers of 10 above restaurant who were trapped in the fire. Subsequently, Moot came to know that unfortunately the said incidence of fire has caused the loss of lives of as many as 40% besides injuring many. But the fact the fire started at the terrace of Moot's hotel at Moot was served. Moot's hotel did not follow the rules as per the Cigarette and the other Tobacco Product Act 2003. The response Panchnama dated 6/8/2021 stated all unfortunate victims have died in the bathroom toilet constructed by a 10 above restaurant, and it appears that there was no ventilation or exhaust fan in the bathroom toilet, but unfortunate death happened due to the suffocation.
As per forensic report, carbonemoglobia was detected in blood sample of victim in forensic examination report date 8/8/2021. So has been arrested on 10 in crime number 291/2020, date 6/8/2021, registered at PM Roshimar Police Station, Document, for the offence punishable under section 304, 337, 338, 216, 285, lead with the section 34 of Indian Penal Code. A bail application was presented before the Magistrate Court, Bhilwara, Mumbai, which came to be rejected on 31st/8/2021. So it has now applied for regular bail before the Session Court, Mumbai, since the state stands framed the accused should be punished for his negligence and nullified intention. The state filed the present appeal to oppose the bail application.
Good afternoon, ma'am. I shall be my colleague Marina. We would like to proceed to the next please.
So, Pali is a resident of Moot estate at the consecutive Raj House, Moot 31. He belongs to a family in the business of hospitality and transport services since several years in central India, which has been their very successful running of various products, resorts, etc. So, has various business at in the name of bikes, transport garage, by automobile, by hospitality private limited, which is running one of the prestigious hotel of Moot city by name Hotel by International. In a corporate company with some of his friends, wherein Shaw is one of the director and shareholder. Upon the obtaining of the necessary permission as required from various authorities for running the business, the company started the business under the name and style as Moot System. By the name of some regional spot as Zamana, and on the night between in 5th and 6th August 2021, when the incident happened, he was nowhere near the said restaurant. He was telephonically informed about it, and at the time he was traveling from home to work. By the time Sir reached the spot at Jamala Mills and met his staff, everything was over and he was not allowed to go near the building as the premises was completely sealed off for the rescue operation.
As it is alleged that the fire had started at the terrace of Sun's hotel as Moot was served, but so
of washing negligent, but also that such rashness of gross negligence was cause of causal and it resulted in the death penalty. In applying the said principle, it cannot be said that applicant had any knowledge that fire would have occurred from his restaurant.
It is humbly submitted for the ultimatum that the accused must be convicted under Section 302 of IPC. It is due to the negligence of accused, sub-pali, 14% have lost their lives and many have been injured. It is humbly submitted before the honorable court that the accused must be convicted under Section 337 and 338 of IPC. It is due to the negligence of accused, sub-pali. He has endangered several lives and many people have been grievously hurt.
It is humbly contended before this auditor that Simpali, who is referred to as the accused, is not guilty of the offence under Section 304 of the Indian Penal Code 1860. In the matter at hand, it has been wrongfully alleged that the accused caused the death of the persons by doing any negligent act. It is contended that the accused Simpali has obtained all the necessary permissions as required from various authorities for running the business, including the permission of fire department. The company of soap by which the restaurant was being run was also granted permission from the fire department. The staff of the soup's restaurant was truly trained staff, due to which the staff was able to locate the building fire and evacuate the guests and others to the safety without any injuries and casualties, and they also helped the customers of the adjoining restaurant neighbors then. Also, no intention of causing death of persons was involved, as the soup was nowhere near the restaurant when the incident happened, as he was traveling from Moot to Bombay after returning from his honeymoon from Australia. It is submitted before this honorable court that in such circumstances, one cannot pinpoint the crime of culpable homicide on the accused, as there is still a room of doubt with respect to negligence and intention of the accused and others cause death of the persons.
It is humbly submitted before the honorable court that the accused must be convicted under Section 216 of IPC because the accused Supali tries to escape from the police when FIR was registered against on him 6/8/2021 and avoided contacting the police.
It is contended before this court that accused is not guilty under Section 260 of the Indian Penal Code, as at the time of the incidents, the accused was nowhere near the restaurant. Some got married on 11/7/21 at Jaipur, and reception was held at Moot on 30/7/21. Sung and his wife Prachi went for honeymoon to Australia on 16/7/21 and returned to India on 4/8/21. The incident happened in between the night of 5th and 6th of August 2021, at the time of which he was traveling from Lyon to Mumbai. He was telephonically informed about the incident after midnight of 5/8/21 while he was still traveling. At the time when he reached the spot, everything was over and he was not allowed to go near the building as the premises was sealed off. Also, there no notice or information that he should not go to any place or he should not contact the police has been provided to him. It is submitted before this court that the accused is not guilty under Section 260, as no proper evidence or facts are introduced by the prosecution.
It is humbly submitted before the honorable court that the accused must be convicted under Section 385 of IPC because due to the negligence of accused Supali, he has endangered several lives and many people have been injured due to the fire caused in Moot's business.
It is contended before the honorable court that the accused is not guilty for any negligent act with respect to fire under Section 238 of IPC, as all the permissions were taken by the accused restaurant, including permission of fire department. It was also alleged that fire started at the terrace of Sub's hotel, as hookah was served, but Sub's hotel was legally permitted to serve the hookah. As the circular issued by the Office of Commissioner of Police on 9/4/2020, it was based on order of the Honorable Supreme Court itself that restaurants are allowed to serve hookah and smoking in the area as per the cigarettes and other tobacco used in their
vicariously liable for the action of the staff and company in general as per section 166 of the Company Act 2013, in which the duty of a director are mentioned section 447 of the Companies Act 2013, in which consequences of abuse of position of the director has been mentioned. In the case Freedom India Telecom Limited Incorporation, corporate criminal liability can be defined as a crime which has been committed by individual or association of individual who, for pursuing a common purpose or make business gain in course of their occupation, commit such act or omission which is forbidden by law and with guilty mind, where it is for the benefit of the corporation or by any individual.
I would like to report a case. The sector officer has been committed versus Anderson. In this case, the Honorable Court has said the prosecution has not properly investigated the fire accident and thereby the accused was acquitted. In the present case also, the prosecution has not properly investigated the fire incident as it is not clear that from where the fire incident was started. Firstly, it was mentioned that the fire has been started from the adjoining restaurant and at last it was damaged that the fire was started from the restaurant also. So it is not clear that from where the fire has been started and no proper evidence as to this fact has been given by the prosecution. So there is reasonable doubt is present in this.
In the light of all aforementioned arguments, the accused humbly submits that there exists reasonable doubt and he should be granted bail for now and should be acquitted of the alleged crime. The prosecution's arguments are leaning toward the fact that the crime may have been committed by the accused. However, they have failed to provide or introduce proper evidence to prove that accused must have committed the crime. Therefore, it is humbly requested before this court that the charge under section 304, 337, 338, 216 and 285 read with section 34 of the Indian Penal Code has not been made out guilty and he should be acquitted of the same.
Government of Bombay versus Abdul Baham. It was stated that his case is grievous hurt. The hurt inflicted only endangers life, but in case of culpable homicide not amounting to murder, the hurt is likely to cause death. The distinction between culpable homicide not amounting to murder and grievous hurt is very thin. So in the given case, the hurt inflicted not only endangers the life but only resulted in the death of 40 people. So the accused is liable to the punished under section 304 of IPC.
I want to submit to the court that such restaurant was legally permitted to serve hookah. He has all the permission from all and every authority, whereas the adjoining restaurant 10 above was not permitted for any of the thing. And the evidence has clearly shown that the victims who have died, they died at the 10 above restaurant 1. No one has died in the son's restaurant. So it is very evident from this fact that the son is not liable for this accident.
Relevant case under section 285 of IPC is Qurban Hussain Muhammad Ali Rangwala versus State of Maharashtra 1964. The paint and varnish factory of the accused catch fire due to which several workers lost their lives and several workers suffered burning injury. As it was a negligent omission to order lighting with fire or any other combustible matter in their possession, which was sufficient the right to guard against any possible danger to human life. The accused was held guilty in the given cases also. So Kogan was served hookah at their restaurant, which was the main reason behind the fire, as the terrace of the restaurant fire due to the hookah coal. So it was a negligent omission on the part of some restaurant, and they failed to prevent the fire, and which ultimately turned out the dangerous to human lives.
I want to remind the court that such restaurant, such staff was especially prepared in behalf. Some has trained in this staff for any kind of emergency or this hazardous situation. And the staff, it was the staff of some who saved all other victims who was present at the Tanaba restaurant as well as in this restaurant. They saved all the lives of other people who were guests as they were present there. So such restaurant is not at fault, and there is no common intention. The the mere fact and here is that the two of the restaurant were adjoining. So